again. Hello everyone. Again, we have another teacher behaving badly. I don't know what's going on lately with these teachers behaving badly coming out of the woodwork. With that being said, let's get into it. Hello. Okay, I just had to make sure I was on.
The allegations against this fifth grade teacher are so shocking, they're hard to believe. Not only did she sexually assault a boy for years, starting when he was just 11 years old, she allegedly had his baby when he was 13.
Lord.
Now a grand jury's indicted Laura Karen, and we are diving into this twisted story. And oh, by the way, she's out on bond.
How?
Presented by Law and Crime. I'm Chris Stewart.
Make no damn sense.
You might still be digesting what I just said there in the open of this show because of what a fifth grade teacher is accused of in South Jersey. Her name is Laura Karen, and there is a lot to unpack in this story when we look at what she's accused of. Before I get to the new details that just came down on this case in just the last week, let me remind you of what Karen allegedly did. Karen was a fifth grade teacher at a public elementary school in Middle Township, New Jersey. It's a town located along the coast near the southernmost tip of the Garden State. This story broke in January, and it was broken in a very unique and explosive way because the father of the alleged victim, who we'll talk about in just a moment, went on Facebook and posted that Karen's 5-year-old son looked very similar to his son, as if his son was the father. Now, Karen's daughter was born in 2019, and that is when the father's son was just 13 years old. Karen was 28. I'll get into what police have allegedly found out as they've been building their case that this 5-year-old girl is in fact the son of a then 13-year-old boy. But here's how Karen allegedly gained access to this young boy. Not only did Karen just teach the alleged victim and his brother, but they lived with Karen. According to court documents, the victim's parents say they struck up a friendship with their boy's fifth grade teacher. They allowed their kids to spend time at her house, and eventually they allowed the kids to spend the night there. And according to court records, quote, it began with 1 or 2 nights a week, and eventually the children stayed with Karen permanently from 2016 to 2020. Now listen, that living arrangement certainly stuck out to us. It's unclear what was going on, that the parents decided that their kids should go and live with their fifth grade teacher for several years. Police spoke with the victim's sister, who also stayed at Karen's house, and she said that she and her siblings would stay in a shared room upstairs in the home. But there were times in the morning when she would wake up and her then 11-year-old brother wouldn't be in the room with them. Instead, he would be in Karen's bedroom sleeping in her bed. She also said that while the other children showered in a second floor bathroom, the victim, her brother, would shower in a first floor bathroom. And she also said that she allegedly saw Karen enter the bathroom and lock the door. According to court documents, Karen sexually abused this victim starting in 2016 when that boy was just 11 years old, and it continued on for 4 years. When interviewed by police, the victim said that he believed that Karen, his former fifth grade teacher, would have sex with him twice a week. And then he continued communication with Karen up until his dad made that Facebook post last year alleging that Karen was the mother of the victim's child. All right, let's talk about those allegations. Not only do police have the Facebook post made by the victim's father, they also allegedly have a screenshot that the victim's sister took of a conversation that she had with the victim, where he, quote, admits he is the father and, quote, requests her not to tell anyone because he does not want Karen to get in trouble. Police also say the victim's mom spoke with her son, and she says that he admitted to her that he is the now 5-year-old girl's dad. Everybody, this is a Law and Crime legal alert. Did you know that children are being diagnosed with serious conditions like type 2 diabetes and non-alcoholic fatty liver disease, and research is potentially linking ultra-processed foods to these outcomes? Our partners at Morgan & Morgan are stepping in to fight to hold food companies accountable. They have decades of experience fighting large corporations, and they're ready to stand up for families who deserve justice. So if your child under 21 has been diagnosed with type 2 diabetes or non-alcoholic fatty liver disease, go to www.forthepeople.com/food. You can also scan the QR code on your screen to learn more.
Choose to lean into it. Every Mazda is engineered to give you effortless control.
I wake up.
Screen to learn more. Karen was arrested on January 15th, less than a month after the Facebook post accusing her of being the mom of a 13-year-old's child, and sexual abuse went public. She was charged with aggravated sexual assault, and endangering the welfare of a child. The school district where she worked said she was put on administrative leave. Now, this is video of the teacher in court per WPVI TV, and according to court records, the former teacher is now out on bond for non-monetary conditions. Now, her defense attorney has pointed out that at this time, there's no DNA evidence that proves that the victim is indeed the father of Karen's child. The alleged father of her child is now 20 years old, and the Daily Mail claims that they spoke with him, and they say he is standing by his former teacher. He claims he wasn't groomed by Karen, but, quote, I started everything. If it was up to me, she wouldn't have been in jail. It's been 6 or 7 years. I'm 19, about to be 20. This week, a grand jury in Cape May County, New Jersey, indicted Karen. The prosecutor on the case, named Jeffrey Sutherland, stated, quote, these allegations are deeply disturbing, particularly given the position of trust the defendant held in relation to the victim. Our office remains committed to protecting the most vulnerable members of our community and will continue to aggressively investigate and prosecute those who violate that trust. Join us now to talk about this case is Practice Professor of Law at Temple University, Marian Bracha. Thank you for taking the time to be with us. This is a shocking story that's taking place not too far from where you live in Philadelphia. Have you seen a case like this before? It just seems, we've talked about teachers who have been accused of crossing the line, but this just seems to be at a whole new level.
Yeah, unfortunately, yes, there have been cases where teachers, those in caregiving positions, those who are really supposed to be the most responsible for the well-being of our children, have engaged in conduct like this. And I have seen and in fact handled other cases where pregnancy has resulted as a result of this context.
What stands out to you in terms of the relationship between this alleged victim and this teacher? Because she taught him, but then he's living at her house with his siblings, and it went on for a long period of time.
Right. Well, I think that the most confounding factor in all of this was the age of the complainant or the alleged victim. At the start, I believe it's alleged that he was only 11 years old, and it continued for a certain number of years. So if you think about an 11-year-old, that's in some instances even pre-pubescent. So it's pretty shocking that sexual contact would have started that young.
What is it about, because we've covered a lot of cases where teachers have had sexual relations with students. What have you found the driving factor is behind so many of these cases where you see a teacher do something like this, allegedly, with someone who is so young and it went on for so long?
Well, I don't want to generalize, and I don't want to say that there is one particular factor or one trait that runs in common across either every defendant who's been accused of a crime like this, or certainly any defendant who's been convicted of a crime like this. I will, however, say that there is diagnostic material that a sex offender would go through an analysis, would go through a psychiatric analysis post-conviction, and there are diagnoses in the DSM that are related to the abuse of children, the adult attraction to children. As disturbing as that may sound to your viewers, that is a diagnosis that is recognized in the medical community. But I think more than that, in a case like this, what we're looking at is someone who really abused the trust and abused the access that they were given to children, and someone who just violated the most basic tenets of trust and caregiving in our society.
Yeah, I mean, incredibly well put, because these are just really, really tough allegations. She's facing charges of not just endangering the welfare of a child, but aggravated sexual assault and sexual assault. What is the difference between those two charges?
So aggravated sexual assault in New Jersey is a felony of the first degree, and in Pennsylvania, the equivalent charge would be the rape of a child. So that is where we are seeing the allegation of the sexual penetration, not only sexual contact, but sexual penetration of a child younger than age 13. The sexual assault charge is a second degree charge that is basically what Pennsylvania and what some other states would call statutory sexual assault. So that means that there was contact with a minor who was under the age of 16, in this case under the age of 13, by an alleged perpetrator who was more than 4 years older than the alleged victim.
Why 30-year-olds love True Classic. Number 1. True Classic tees are designed for regular guys. Most brands make t-shirts for models, which is great for models, but unrealistic for everyone else. They are tied around your arms and shoulders, which makes you look built, but
more than 4 years older than the alleged victim. So that's why there are two charges that do not merge. They carry different elements that must be proven by the prosecution on all counts.
Last week, she was indicted by a grand jury on these charges, and I've often heard people say that it's very simple to get a grand jury indictment, but what actually happens during that? What type of evidence is presented, and what is the bar to get that? Is it really that easy to get a grand jury indictment, as much as I think sometimes you hear attorneys say?
So I think that some of the resistance and some of the bad rap, if you will, against a grand jury proceeding is that the defense is not present. So the defendant is not present at those proceedings. There is no cross-examination of the prosecution witnesses at those proceedings by and large. There are certainly exceptions, and there are certainly states that handle a grand jury very differently. But the bar is at any pre-trial hearing, the standard really is prima facie. So at a pre-trial or at a preliminary hearing, what the prosecution has to prove is that it is more likely than not that a crime was committed, and that it is more likely than not that the person who's accused, that the named defendant, was the person who committed that crime. So they do have to establish that a crime was committed and that the person they are seeking to charge is more likely than not the person who committed that crime. Again, that is a lesser standard than what we have heard and what we know from trial, which is beyond a reasonable doubt. If this case goes to trial, the defendant would absolutely have the Fifth Amendment right to confrontation, would have the right to be present for any testimony presented against her by either the complaining witness or any other expert witnesses who the prosecution would call. And of course, in order for a conviction to attach, a fact finder, either a judge or a jury, would have to find that the prosecution proved every element of every crime charged against this defendant beyond a reasonable doubt, which is the standard that has applied to criminal cases for the 200 and almost 50 years of this country's existence.
And one thing I noticed is they have members of the victim's family saying that he has said that he is the father of this now 5-year-old daughter, who allegedly was born when he was just 13 years old, but they don't have the DNA. They don't have the paternity test to prove. What is the process of getting that, if you're the prosecution, to have that piece of evidence, assuming that now that she has a defense attorney, that there may have to be some back and forth?
Sure. I mean, there's almost certainly going to be a search warrant executed for her DNA, for the child's DNA, for the alleged victim's DNA. There are certain things that we do not have an expectation of privacy in. We do not have an expectation of privacy in our appearance. We walk down the street with our face showing. We don't have an expectation of privacy in our fingerprints, because we leave fingerprints everywhere, on subway stations, on glass doors, on surfaces that we touch in coffee shops. So our DNA is actually something that we leave, that we don't have an expectation of privacy in. It will be, I would think, a rather straightforward process for the prosecution to request a search warrant from a judge or from a magistrate in New Jersey to have that search warrant executed, meaning that a buccal swab will be taken. It looks like a tongue depressor, but it's plastic and it scrapes along the inside of a subject's mouth to take the cells, buccal cells from a person's mouth, and then those the results of that DNA sample would be compared and could be used in court to prove that the offspring between the defendant and the alleged victim was the result of sexual intercourse between them.
Whether or not she had his baby, which is just it's a wild accusation, but it wouldn't change the fact that she allegedly sexually assaulted him and she's charged with that sexual abuse. How does the baby factor into what her punishment could be and how this trial goes forward?
Well, first of all, the baby, I hate to say it, is probably the best physical evidence that exists that there was sexual contact and sexual penetration in this case, because the baby and the DNA from that baby would be the proof that these two people reproduced together. And of course, the only way to do that, unless they're alleging that there was some kind of in vitro fertilization, but the only way to have done that would have been through sexual contact, through sexual penetration. So will the baby factor into a sentencing decision? Maybe. I have seen judges take into consideration female defendants who have children or who have sole caregiving responsibility. But what makes this complicated, especially in the state of New Jersey, is that there are enhanced penalties attached to that aggravated sexual assault charge. So while felony and first degree might carry 10 to 20 years in New Jersey, this particular charge under an act that was enacted several years ago would carry enhanced penalties, so it could be 25 to life. And there are certain negotiations that the prosecution could enter into that might reduce the sentence 15 years, but I believe under that same act in New Jersey, 85% of the sentence imposed would have to be served before a defendant would be eligible
She need to do
for
some
in a
time.
case like this. So the baby might factor into a conversation regarding plea negotiations, but under the language of this particular act in New Jersey, the sentencing enhancement is pretty serious.
How effective are those sentencing enhancement laws when they go in terms of getting plea deals or seeing impacts to cases like this? And I don't know if scaring people away from doing the crime is the right term, but how effective do you see some of these enhancements actually on issues like this?
Well, we're going to get into a pretty philosophical discussion about the effectiveness of deterrence, right? And if our sentencing guidelines are even effective deterrence at all. But in a case like this, I think that the availability of a sentence enhancement is probably more useful when it comes to the prosecution's position for negotiating and for entering into any kind of plea arrangement or plea agreement where the defendant might plead guilty to either a lesser included charge or to an agreed upon sentence, for less than the 25-year enhanced penalty that the aggravated charge would carry. I don't know that these enacted sentence enhancements, either on sexual assault crimes or on crimes of violence, crimes with deadly weapons, even homicide charges, I don't know how effective, or if our current research shows us that they are effective in terms of deterrence, because
have you heard? Reading glasses are outdated. A new technology for the elderly. Nothingness is here. From now on,
shows us that they are effective in terms of deterrence, because I hate to be nihilistic, but people will act the way they will act, and so I don't know that they're necessarily
unfortunately, yes,
when they're engaging in criminal behavior.
Then in this case, in the text message that the victim's sister apparently has, where she says, admits that he is the father of this now 5-year-old child, and part of it is he says he doesn't want the teacher, he doesn't want Laura Karen to get in trouble. And do you find it difficult for victims to kind of understand that they are victims in stories like this?
I do, unfortunately, especially in cases where, and I hate to be gendered, and I hate to generalize again, but in cases where the victim or the alleged victim is male, there are, I think, a lot of cultural biases that apply to say that, when a male victim is at the center center of a case like this, that maybe there was consent, or maybe that the male victim was mature beyond their years and could handle or could understand the sexual activity that was happening. And I think that is unfortunately a very gendered cultural bias that we should be challenging, and that is being challenged by prosecutions like this. And it is unfortunately a very common occurrence to have to explain to a victim as young as 13, or at this point now, 16, that they really didn't have the capacity to consent when they were as young as 11 or 12 or 13. And that is oftentimes, in my experience, something that these victims don't come to appreciate until much later in life.
And then in this case, if the allegations, and it seems like the prosecution has to this point, they have certainly allegations against her, but how do you see this case proceeding forward?
Well, now that they have the grand jury indictment secured, I would assume that they will, if they haven't already pursued search warrants for the DNA evidence, that they would pursue subpoenas for that, for DNA, for forensic testing to compare the paternity, to compare the samples. They would also probably subpoena records of vital statistics, things like birth certificates and hospital records from where the child was born, to show the date and the memorialization of how many weeks along gestation the child was when born, and that kind of establishes the timeline for the sexual contact that allegedly occurred between the defendant and the victim. So I would assume that between the grand jury indictment and any pretrial proceedings that are scheduled, that the investigation will be ongoing, that records will be gathered, that discovery will be passed, and perhaps there will be conversations between the defense and the prosecution about possible non-trial dispositions that would perhaps alleviate the enhanced sentence that could attach to a conviction like this.
We'll see how it all plays out. Marion Bracha, it's always great to have you on Law and Crime. Thanks for talking about this one with us.